I'll put one more question out to the floor. This isn't one that has to be answered now, but I think it's one that might be worth considering. And so I'd pose the question to Mr. Sadow. If your client does win election in 2024, could he even be tried in 2025?
The answer to that is, I believe that under the Supremacy Clause and his duties as President of the United States, that this trial would not take place at all until after he left his term of office.
Solely is against him.
Solely against him.
All right. And Mr. Wade, again, I'll give you the opportunity to respond if you so desire. All right. I think obviously that's something we're going to be taking up in greater detail and the new year. And when it comes to the issue of severance, without foreclosing any of the substantive arguments for severance that I'm sure will be filed and need to be made and considered, I think, as Mr. Samuel points out, the logistical concerns are still there. Certainly, I think most, at least I know the state, I know in terms of a preference for conserving just court time and judicial resources, the goal would be to try the case once, again, solely from a logistical standpoint. But I think a lot of the arguments and things that I put in that order would still hold true even with 15 defendants. And so, again, just putting out initial reactions is that even if there is as we get closer to the time of trial, a severance due to logistical issues, it's my understanding under the Joinder statute that the state would have the ability, and it says shall be able to choose the order. And so if we set a limit, that we just feel, court feels 8's the most we can do at once. My initial thought was that the state would be able to choose an A league and a B league. And if cases resolve on the eve of trial, the folks on the B list better be ready to sub in. But that I don't think I can, I'm willing to say definitively that all 15, if that's who are left come the trial date, that no ifs, ands, or buts, they're all joined together. That's where I am now. But like I said, this is more just to solicit input and reactions. So, Mr. Wade?
No, we do know, Judge, by just historically, 12 defendants have been successfully tried. So would the court be inclined to consider it?
I don't want to set a number today. I think, again, we're still a little too far out to do that. But I think we can recognize 12 is not 15, and 12 is very much pushing those boundaries. But as I mentioned, I think the state would have the statutory right to choose who would fill those chairs. And in the interests of efficiency, if one of those chairs is emptied the morning of voir dire, someone else would be filling in.
So 8 is not a hard and fast?
Oh, no, absolutely not. No, not at all. I'm not committing to any number at this point. But that's just how I was, at this point, viewing logistical severance. I don't know, Mr. Samuel, just because you raised the point, was there anything you wanted to add?
Oh, I think the lawyers have all been discussing severance, and I think you described it once as which bucket are we all going to be in, and we've had a lot of conversations about it. I don't think we've formulated a specific response, but if you gave us a deadline to make a proposal, I bet we could meet your deadline.
Sure. All right. Thank you all.
Maybe two different deadlines, one for one bucket and one for the other.
Okay. In the near term, though, we have Mr. Clark and Mr. Meadows who have been waiting here. We've covered a lot of ground since then. I think the state's position was that it was consenting to a February date?
Not past February 1st.
Okay. All right. So if the state's consenting, then, again, I was more on the fence with Mr. Meadows, but to that extent, we can say that the motions deadline would extend to February 1st. And we can do that. I think the same with Mr. Clark. Again, we're in another situation where there's a lot going on and a lot changes week by week. So with the state's consent, we'll extend the motions deadline solely for Mr. Clark and Mr. Meadows to February 1st.
Your Honor, on that, assuming that either one of those defendants were to come up with a unique motion which had not been raised by any other defendant, would we at least be in a position to adopt for purposes of the record?
I'll consider a motion requesting to adopt. Let's go that way. I don't think all motions are created equal, and we'll. I do want to have that January date be a hard and fast, because so far, I think we've had a lot of hands at the table, and the issues are starting to appear similar in most respects. And I'd like to see what we come up with in January.
I'll take that as a maybe.
We'll go with a maybe. I'll say a maybe, but unlikely. I'll put it that way, Mr. Sadow.
Maybe minus?
It may be minus because with the pretrial litigation that's expected, we have to have a stop date, or at least a start date. Okay, so I think, Mr. McNeil, that handles your business today? All right.
I plan to stick around.
Feel free.
The elevated arguments to come.
Okay, if we're still standing here. All right, anything else then from Mr. Durham? You're also, okay.
Thank you.
All right, so if there's nothing else from the state, then we're moving on. The remaining issues, and that may have taken care of, no, I don't think it did actually, the housekeeping and discovery issues, but I wonder if we can combine, or if council were planning to combine issues 3 through 7 as articulated by the proposed agenda. No, not so much.
Well, there are a lot of similar issues. I'm doing item number 3, which is the solicitation counts.
Okay, well, let's just start there then. How much time do you need?
At most, I would guess 20 minutes.
All right.
And I do want to begin, if I can, by making sure the court is aware of how we structure the agenda. It is not defendant by defendant, nor is it even count by count. It's really topic by topic. And there's a lot of adoptions, but it should be clear that, like with regard to Ray Smith's demurs, we demurred to, I don't know how many counts altogether, probably just about everything he was charged with, and he's been charged with the third most counts. But we're not arguing all those today. In fact, Mr. Anulewicz will be arguing the false statement counts to the legislature, even though we're in the exact same counts and even some additional ones. So I'm doing anything that involves the solicitation at the legislature. Mr. Anulewicz is doing anything that involves false statements at the legislature. We are also in a couple counts in different ways dealing with the alternate electors, contingent electors, or the electors, and we adopt, and we'll do it in writing also, all the arguments you heard this morning there. But otherwise, you were going to hear from every one of us on every topic, which we've done everything we could to be more efficient. So the counts, if that's okay with the court. So the counts that I'm going to be focusing on in particular, counts 2, 6, and 23. Those are the 3 substantive counts alleging solicitation to violate a legislator's, or plural, legislators' oath of office. And they are, in all relevant respects, identical. They differ in dates, and they differ which legislative body Mr. Smith appeared before. And in each of them, there are a number of defendants, and I think we're all adopting each other, but I am handling these 3 counts, 2, 6, and 23. Count 2 alleges an appearance before the legislature on December 3rd. All these dates are 2020, of course. Count 6 alleges an appearance before the legislature on December 10th. And count 23 involves an appearance before the legislature on December 30th. These are not the 4th time that he appears at the Capitol is with the electors on December 14th. That was argued by Mr. Gillen, Ms. Pearson, and we adopt their arguments with regard to that, the allegations involving what happened on December 14th and the related time frame. So I'm focusing on the solicitation counts. And the solicitation counts are virtually all identical, again, other than the dates. Let me just summarize really briefly count 2 as an example. And this applies to a large extent on the overt acts in the RICO, but we're not asking you to grant a demur with regard to them because they're not, most of these are not alleged to be crimes at all, even in the as predicate acts. So that's really the substantive counts, 2, 6, and 23. To the extent that any of them are mirrored in a RICO count, actually my partner will be arguing the RICO objection hopefully before nightfall, and she will, the reason we put that at the end, just so you know, is because otherwise she'd be dealing with every single substantive count also. So count two. Count two alleges, as I said, that on the December 3rd, 2020, Mr. Smith, along with Mr. Giuliani, Mr. Eastman, Ms. Ellis, appeared before the legislature and unlawfully solicited members of the Senate Judiciary Committee, who were identified, many of whom were identified in the indictment itself, to engage in conduct constituting the felony offense of violating the oath of office. You have a solicitation allegation asking someone to engage in conduct which would amount to a crime, and the crime is violating your oath, the oath you took before you became either a Senate or a member of the House, depending on which count we're looking at, but all virtually the same. And then it identifies what you asked the legislators to do, which they claim would violate their oath. All the same, all three counts. They were asked to unlawfully appoint presidential electors from the state of Georgia. Okay? I'm just going to address those allegations because, as I've now said 3 times, they apply to all 3 counts of the indictment. We are challenging these indictments both under under the special demur and a general demur. And I'm, for those of us who spend a lot of time in federal court, and as you did for many years, they are not unlike, in terms of what you're seeking, a bill of particulars. A special demur is not unlike a bill of particulars that you would use in federal court. And in old civil practice, before the Civil Practice Act, it's not unlike, a motion for a more definite statement or something else that challenges, I'm talking about special demurs now. It challenges the amount of information that was given to you in the charging document, whether it even applies in civil cases. And as you know from both parties' submissions, I'm just getting my computer warmed up. You don't need to read a whole lot of case law to understand special demurs. You really only need to read 2 cases, and I think they're the cases that the prosecution cites and the defense. And one is the case of State v. Sanders, which the state cites, oddly enough, because it's so favorable to the defense. And the other is the Kimbrough case, which was a fairly remarkable case, finding a special demur should have been granted, leading to the dismissal of the indictment. In a RICO case, I don't know who argued that case in the Supreme Court, but whoever did was surely brilliant. Do you happen to know who argued that, Judge? Yeah, okay, yeah, all right. So here's the problem with the indictment, and I, with all due respect to my colleagues, I'm not sure I understand really what their response is, other than we've alleged the 3 elements of the crime. That's all we have to do. We allege that you solicited. We told you who you solicited and when and what you asked them to do. Period. End of discussion. We don't have to do anything more. And in fact, they didn't do anything more, because at a minimum, what we seek in our special demur is, would you mind telling us what oath it is that you claim that we took? What was the oath we took? I've done many oath of office cases. We've represented county commissioners. When they do something inappropriate, they engage in some kind of, shenanigans, and they've taken some money they shouldn't take, and you always find out what the oath was that they took. More often, we represent police officers who are alleged to have committed a violation of their oath of office because they did something wrong. Usually, an excessive force case, or maybe some sexual impropriety with an arrestee, or a financial crime. But you're always told what the oath was, because that, in essence, defines what you did that was illegal. You violated the oath, which required that you XYZ. And so we filed a special demur in this case to find out what oath it is that you say we took. You think it would be simple. Why don't you just go look it up yourself? Well, the answer is many public officials take different oaths. Policemen, for example, they take an oath under the county, they take an oath by the state. There's 4 or 5 different oaths they have to take. the city, the county, the state, and the oath, the post certification oath. And you're always told what is the oath that you violated. I looked in the code. I started at OCGA 1-1-1 to make sure I didn't miss a certain oath that perhaps a legislator took. This is the first time I've ever had an oath of office case, ever. I've been practicing 40 years, in which the oath wasn't attached to the indictment, or the date that they took it, or at least the content of it is spelled out in the indictment itself. And I found that there was only one oath that legislators take. And if I'm wrong, it shows even more why we're entitled to a special demurrer. I'm assuming that the prosecution doesn't disagree that this is the oath that was taken, but I'm just guessing that this is the oath they're referring to, because I don't know of any other oath they took. We should have been told. But I found an oath in the code at Title 28, never looked at that before, Title 28-1-4. And it says, it begins, in addition to any other oath you took. I have no idea if they took another oath, because they didn't tell us. In addition to any other oath prescribed by law, each senator and representative, before taking the seat to which elected, shall take the following oath. I do solemnly swear or affirm that I will support the Constitution of the state and of the United States. That's it. Then there's a reference to, I'll conduct myself, in accordance with that oath. So I attached, for your benefit, a copy of a decision from a judge down in the Brunswick Judicial Circuit, which was the last oath of office case I took. And there, they alleged you violated your oath. They gave us the oath, in that case at least. And in that case, the oath said, like this, I swear I will defend the Constitution. And the judge said, that's too broad. You haven't given Mr. Samuel, Ms. Clark Palmer was in that case too, you haven't given them enough information. What clause in the Constitution, what part of the oath did you supposedly violate? And I pose the same question here. Assuming this is the only oath, and if it's not, you ought to automatically give a special demurrer since they didn't even tell us what oath it was. What portion of the United States Constitution or the Georgia Constitution, because that's in the oath also, Georgia and United Constitution, what clause in the Constitution are you claiming we asked the legislators to violate? Was it the Equal Protection Clause? Because voters in different counties, Fulton County was rife with fraud. Did they get more than one man, one vote, or one person, one vote in Fulton County? Because I've seen election challenges in this election dealing with equal protection. Was it due process? Was it what I learned about this morning, Article 2, Section 1? Is that the violation of the Constitution that was allegedly solicited of the legislators? We have no idea. We don't know what we are going to be defending against. We don't know what it is, what portion of the oath we supposedly violated by asking legislators to, I call them, coronate the electors, which is all they're alleged to have done. Appeared before the legislature and said, please, select these alternate electors. Once we are told what the oath was, which we haven't been, once we are told, assuming it's the Constitution that we were soliciting people to violate, what is it about the Constitution says you can't ask a legislator to appoint an elector? There's nothing in the Constitution that says you can't do that. There's nothing in the Constitution that says a legislator can't do something like that. How does that violate the Constitution? The prosecution's saying it's a crime. We're saying it's constitutionally mandated that we have the right to do that. That's what Ms. Pearson and Mr. Gillen said this morning. But now the state's going to have to say it would violate the Constitution somewhere, somehow. Georgia Constitution, federal Constitution, we have no idea, to even ask the legislature to appoint alternate electors. It's the same in count 2, it's the same in count 6, same in count 23, exact same conduct each time. The prosecution responds, well, we've set forth the law and the elements of the offense. But that's not what a special demur requires. And again, I'll quote from the Kimbrough decision. The indictment must allege the underlying facts. Kind of gets into the as-applied issues you were dealing with before. But now we're in the context of a demur where Kimbrough said, you must allege the facts which actually constitute the offense so that we are prepared. That's why we've asked, tell us the oath, show us the oath. Put it in the discovery, which would not be a adequate substitute, but they haven't even done that. They say in their response, it's no more necessary for us to tell you how you violated the Constitution than in a murder for hire case to say, whether we want you to use poison, a gun, or a knife. And that's a clever response, but totally inapt. It would be as if, we said, go kill somebody. Would that be enough? A solicitation, go kill somebody somewhere, somehow. That's the amount of information we've gotten in this case as far as the solicitation case goes. This isn't a conspiracy count. These are all, you solicited to these legislators to violate their oath in order to, so that they would violate their oath, apparently their constitutional obligation. They say we can look elsewhere in the indictment, but that's not the answer. A special demur has to be satisfied if the count doesn't allege sufficient facts to allow for the preparation. If the count doesn't allege the sufficient fact, discovery is not a cure. Oral argument here is not a cure. If Mr. Wooten stands up and says, I'll answer all his questions today, that would be a concession that the indictment is not enough. When he responds to this, he should stand up and say, I'm not going to tell you anything more, I don't have to. Because once he starts answering questions and saying, okay, I'll tell you where the oath is, I'll tell you what part of the oath was violated, I'll tell you the constitutional provision that was, you solicited the legislators to violate, he's acknowledging, he's conceding that the indictment was not sufficient, and he had to fill in the gaps by standing in court and telling, is he going to promise, is he going to promise those are going to be the allegations in the indictment?
Well, I know you made this reference earlier. I know the bill of particulars isn't recognized, I think, explicitly in Georgia law. Right. But that's essentially what you want. Well, you want indictment perfect in form and substance.
That's my next line. Thank you.
There you have it.
You've jumped the gun on that. But the difference between a bill of particulars and a special demur is the relief that has to be granted. Bill of particulars in federal courts are very, can I say, gentlemanly thing to do. And the judge says, just answer his question. You're bound by it.
And you're bound by it.
Yeah. That's not the way it works here. You have to dismiss the count here. It's the only way to resolve a special demur. If you agree that the indictment is defective in terms of not providing sufficient information, you must dismiss that count. That count gets dismissed, and they can reindict, they can do whatever they want to do. But discovery is not the answer. An informal response in court is not, or even a formal response, even if he takes an oath and tells us what the answer to my questions are. And none of that is sufficient. It's a dismissal.
Agreement between the parties, and that's not an answer either.
Well,
or one that's not at.
We're not going to agree that we don't get a special demur. Special demur says you must have an indictment that is perfect in form and substance. I love Mr. Anulowitz and his colleagues' description of an indictment. According to Kimbrough, according to cases that go back 30 years, they have to get an A. It has to be perfect in form and substance. It can't be an okay or an adequate or even a B+ indictment. It has to be an A. If we were grading on a curve here, this indictment, perhaps, this indictment deserves a B, but only because so much of the remaining parts are so pitiful. So, our special demur is we want to know what was the oath, what part of the Constitution, if the oath is the Constitution, to obey the Constitution, what clause in the Constitution were they solicited to violate? And why would that be a crime? let me turn to the general demur, which, well, I have one more example here. This indictment would be as if you were charged with violating your oath of office, or I asked you to violate your oath of office because you came into court, you know, without a robe this morning, or some judge came into court without a robe. Isn't it clearly the law that the judge would be entitled to say, what oath did I ever took that required me to wear an oath? I want to know the oath that you claim I violated. And they're saying we don't even have to tell you that. You can just, you'll find out at trial. That's when you're going to find out the oath you violated and the portion of the oath that was violated. Let me turn to the general demur aspects of this claim. Again, the allegation is that Mr. Smith and others, Mr. Giuliani, Mr. Eastman, I guess, and Ms. Ellis, went to the legislature. They're invited to go to the legislature to answer questions of the legislators. And when they go there, they urge the legislators, this is what's in the indictment, this is, you know, forget the facts, outside the four corners. And while there, they make statements that are asking the legislators to appoint the slate of alternate electors. And apparently the allegation is that that violates the Constitution. They're asking the legislators to do something that is unconstitutional, assuming those facts are all true, as a general demur must do. That is no different than a lobbyist who goes to the legislature, the examples from my brief, and says, you should pass a law that says any book that has the word sex in it should not be allowed in the public library. If someone went to the legislature, a lobbyist went to the legislature and said that, I want you to pass a law that says you can't bring a book that has the word sex in it to a library, clearly a First Amendment violation, right? Nobody would doubt that. But under their theory, you're violating your oath. You're soliciting a violation of the legislator's oath because the lobbyist asked the legislator to do that, to do something that would violate his oath because he passed a law that violated the Constitution. Think of the pre-Dobbs decision, the abortion cases, where
So this, just to be clear, this line of your argument is premised solely on if the oath that they're referring to is Constitution.
Listen, if I'm wrong about that, I'll sit down. If they stand up and say you found the wrong oath, you just grant the special demur and we'll start over again. I mean, really, that's we laugh, but that's the whole point of the special demurs is make sure I got the right oath, okay? If there's some other oath that the legislators took, I mean, usually they're in writing and they're attached to the indictment. Do they have the written oath, the signed document? The problem with this, from a general demur standpoint, is even if they did that, even if I'm right that the oath of office they violated was the oath to obey the Constitution, it's not a crime. We can admit every fact, other than obviously the allegation that it's unlawful. You don't have to ever concede that fact for a general demur. And it would violate the First Amendment to say you can't go to the legislature and ask them to pass a law saying all abortions should be illegal, pre-Dobbs. Right? Because that was unconstitutional at the time. Roe v. Wade said that all abortions can't be illegal. You're not allowed to go to the legislature and ask them to do something like that because you're soliciting them to violate their oath, which is to be constitutional. And the solicitation statute, the Davis case that Mr. Sadow raised before, and I think is not Hall, but Davis, the other case, what you're asking the legislators to do, it has to pose a clear and present danger. That's the Davis decision. A clear and present danger that they're going to be committing a crime if they did it, if they followed through on the solicitation. That's Davis, 246 Georgia, 761. Not only is there not a clear and present danger, it's not even a crime. It's not even a crime. It's this compound defense where you're violating the oath of office, which doesn't violate anything. There's nothing in their oath that says they can't pass a law It's unconstitutional. They do it all the time. Don't tell them I said that, but they do it all the time. That's why we have challenges to statutes all the time, challenging the constitutionality of statutes. Your brethren on the bench in this courthouse have found statutes unconstitutional. Did they throw the legislators in jail? Did they say the legislators violated their oath of office when they passed the law? Of course not. Other aspects of the First Amendment that apply to the general demur here is the lawyer's duty. We talked about that a little bit in our brief, to advocate on behalf of a client, to urge legislators. This is, I'm trespassing a little bit on Mr. Anulowicz's First Amendment argument. So, asking legislators to appoint presidential electors doesn't violate the Constitution, doesn't violate the legislators' Constitution, even if they were to do it. You couldn't put the legislators in jail for doing it, not for violating their oath of office, not for violating the United States Constitution. We'd ask you to start with the special demur and then move on to the general demur. If their answer is yes, the only violation we're alleging is the violation of the oath to obey the Constitution, and the only violation of the Constitution is exactly what is described in the indictment, requesting that they appoint alternate electors, then we believe we are entitled to a demur. The only other thing I'd mention, I mentioned the Sanders case and the Kimbrough case. In Sanders, the allegation in the indictment was you solicited someone to either possess with intent to distribute or to distribute a controlled substance. It's clearly a crime, clearly alleges a crime under the Georgia Code. And Justice Bethel said, that's not enough. You have to say which drug. Okay? You have to say which drug it was that the defendant was solicited to possess. It's not enough just to set forth the elements of the crime. You have to give them more information. And that's the Sanders case, and it's even in the state's brief. They cite even that portion of the Sanders case, that it's just reciting elements of the offense doesn't put us on sufficient notice of what the crime is.
Thank you, Mr. Samuel.
Thank you.
Yeah,
Following on Mr. Samuel's argument.
1 second, sir. We got to get our court reporter back up.
Following on Mr. Samuel's argument, I want to talk specifically about an additional issue that applies specifically to count 23. In that count, they're charged, Mr. Cheeley, Mr. Giuliani, and Mr. Smith are charged with solicitation of the violation of oath on December 30th, in that they allegedly solicited the Georgia State Senators to violate their oath by appointing the alternate slate of electors. Your Honor, this is subject to general demur because it's a temporal impossibility. Looking at the indictment, as detailed in Overt Acts 78 through 85, the contingent alternate slate of electors was done, was completed, and the associated paperwork had been transmitted on December 14th, 2020. And incidentally, none of those overt acts involve or name Mr. Cheeley. As the actions have been completed well before December 30th, as is described in the indictment, there is no possibility, even admitting every fact in count 23, that any of those defendants could have solicited them to violate their oath, because what they were supposedly being solicited to do had already been done and had already been complete. Thank you.
And Your Honor, I have one point to address. Your Honor, I address the matter that was raised by the state's motion to restrict, which the court has already commented on. I just wanted to point out that in the motion to adopt, the first one that I did, which was filed on September 11th of 2023 as to Mr. Smith, and also I did an amended motion to just be as clear as I could be on October 24th, 2023. I indicated in a footnote on page 1 that Mr. Smith, that is the defendant that Mr. Samuel represents, that his demurs to count 6 applies to counts 5, 28, and 38, which charge President Trump with the same offense. All 3 of the offenses involves solicitation. The oath issue is the same. The First Amendment issue on Davis is the same. We don't have the legislature issue. So those have already been brought to the court's attention through my adoption motion. It's nothing that was new to the state. It's right there in the footnote on both of the documents that I filed.
Okay, thank you, sir. Mr. Wooten, I presume. All right.
I'm going to go a little bit out of order, starting with the argument related to temporal impossibility. That is a pure speaking demur. That's going to facts outside what's alleged in the indictment. It's void. The court should disregard that argument altogether. Moving on to Mr. Samuel's argument. He makes great arguments if his client were charged with violation of oath of office. And his client is not charged with violation of oath of office. He's charged with solicitation of violation of oath of office, which is an entirely different crime with entirely different elements. Our inchoate offenses, solicitation, attempt, conspiracy, do not have the same elements as the target offenses. Any target offense. You can use any other offense as a target offense for one of those inchoates. They don't have the same elements. They have different elements, and so the pleading requirements are different. And each of these counts survives general demur. They all allege the essential elements, and they all apprise the defendant of what he or she must be prepared to meet, and they provide enough detail to protect against double jeopardy. Again, indictment is not required in this case because of solicitation to allege the oath of office or the portion of the oath violated. So let's look at the elements of criminal solicitation. With intent that another person engage in conduct constituting a felony, a person solicits, requests, commands, importunes, or otherwise attempts to cause the other person to engage in such conduct. Those are the elements. That's it.
Sure, but maybe let me try this argument out on maybe a count that is litigated a little bit more frequently. And solicitation, you'd have to, is an umbrella that encompasses some other felony because something has to be solicited. So I'm just thinking off the cuff here, felony murder is an umbrella count that has to have a predicate felony. And when we look at an indictment, usually with a felony murder count, it's going to say aggravated assault. And we can go down the indictment and we'll look at the aggravated assault, and then there'll be a little bit more detail about that aggravated assault. But we don't have that in this indictment, do we? Where there's a little more detail about that count.
I disagree there, Judge.
Okay.
I disagree. Let me see if let me skip ahead to that portion. Well, let me just talk about it. I don't have the case site in front of me. The case law is very clear on this. And the other side, I believe Mr. Nolowitz talked about this in his reply to our response. Cited a case saying that every count has to allege everything.
Well, I'll take your point that you can do the entire indictment, right?
Right.
Okay.
Right.
So we can look at the whole indictment.
Right.
Where else in the indictment do we break down what part of the oath was violated? He needs to know whether it's the Constitution or whether it's, I don't even know what else is in the oath, but.
And Judge, that's where
not to be a communist. I think that's usually in there, right?
Right.
But what part of the oath, where else is that in the indictment?
That's where we disagree. That the portion of the oath does not appear in the indictment, but the state's position is that it does not have to appear in the indictment because the portion of the oath is something that has to be pled for a violation of oath of office, not for criminal solicitation. They're completely different pleading requirements. And I give an illustration to that. It wasn't solicitation of murder. Mr. Samuel said we use an argument. It's not murder because there's essentially one way to commit malice murder. I use aggravated assault for a reason because there's at least 4 distinct ways to violate the aggravated assault statute. And does a person who's soliciting someone to commit aggravated assault have to specify?
Do we have a case on that?
We don't. Admittedly, we don't. I think there's one case that deals with a special demur to a criminal solicitation count, and that is Sanders, and it's dealing with the controlled substance issue.
So then the answer to this could be yes.
Our position, and we argue to the court that it's not. And the reason why is because the person who's doing the solicitation in this situation doesn't have to know how the person that they're soliciting is going to commit the crime. And so if they don't have to know how the person is going to commit the crime, then how could the state ever allege how they solicited someone, like what specific provision of the aggravated assault statute they solicited someone to commit if they're not required to do that in the first place? And so the example that we use is that, if person A goes to person B, says, here's $10,000. I want you to take care of person C, rough them up real good, make sure they're never a problem for me again. That's enough. It doesn't matter if, a person B shoots person C, commits a drive-by shooting against person C, strangles person C, clubs person C, maces them. None of that matters. Those are all separate and distinct ways of violating the aggravated assault statute. But if person A is not even required to know how the statute would be violated, then how would the state be required to allege the manner in which A solicited B to violate the statute? It's impossible. So it can't be a requirement that in criminal solicitation you have to allege that a solicitation was done in a particular way, because the solicitation itself doesn't have to be done in a particular way. And again, the state can't allege what specific provision person A solicited B to violate because person A never specified one. And that's the same way here. None of these defendants said, I want you to violate this portion of your oath. They're not even, I don't know that they're required to even know that the legislators have taken an oath. That's not raised, and that's an issue for another day. But none of them say, I want you to do it in this way, or I want you to do it in that way, or I want you to violate the Georgia Constitution, or I want you to violate the United States Constitution, or I want you to violate this provision. They're not required to solicit in that way. And so the state cannot be required, in order to be guilty of the crime, so the state can't be required to plead something that doesn't have to be proven. And again, the cases that are relied on by the defendants are inapplicable.
Is there a distinction there, though, between what the state has to prove in terms of knowledge and what the state has to prove as of the effect of their actions? If that makes sense. So, yes, the state doesn't have to prove what aspect of the oath that they were soliciting the violation of. But if the state does have to show the ultimate effect of it, or that's.
And Judge, I think to answer your question, the state may have to prove knowledge. I don't know, but we're not talking about proof because these are motions to dismiss an indictment. We're talking about allegations. And so we point that out in some later arguments, and we point that out in our briefs, that often in these arguments we see the defendants conflating, sufficiency of the evidence with a pleading requirement, and they are not the same thing at all. And so, while we may have to prove at trial X, Y, or Z, we don't have to allege all of those things. And so there's no grounds upon which, in our opinion, and again, it's to my point, cases concerning sufficiency of the evidence, they're irrelevant to a demurrer because that's not dealing with what has to be pled in an indictment. That's dealing with what has to be proven at trial. And they're very, very different things. Also, it's irrelevant that it's not a violation of oath of office to enact unconstitutional legislation. The indictment doesn't allege that they asked legislators to enact unconstitutional legislation. It doesn't specify exactly, how they were to unlawfully appoint presidential electors, but that includes getting rid of the actual will of the voters in this state, throwing those out, and figuring out some way to say, nope, these are the electors. The defendants themselves weren't quite sure how they were going to do that, so there wasn't a fully developed plan. And I hesitate to speak to facts outside of the indictment, but I don't find this to be a compelling argument. Again, because it alleges criminal solicitation, and it's for the jury to determine whether or not the proof rises to the level of proof beyond a reasonable doubt of criminal solicitation. Again, I don't know that this argument was raised in the oral arguments, but in the briefs there was an argument that it's not a violation of oath of office to do X, Y, Z, or maybe they're immune because of legislative immunity. None of that matters because the solicitation statute itself says It's not a defense to prosecution for criminal solicitation. The person solicited could not be guilty of the crime solicited. Again, there was raised in the pleadings that we haven't alleged a nexus between appointing presidential electors and official duties. Well, that nexus appears in the Constitution, but once again, this is an issue of proof at trial and not a pleading requirement. Again, Judge, these motions should be denied because this is a criminal solicitation charge. The elements of the offense are different than the underlying target crime. We do not have to plead that level of specificity. It's not a defense that the legislators couldn't have been guilty. The remaining issues are for the jury. And I do want to point out, Judge, that as it relates to the special demurrer, what we do allege, and this is contrasting with Sanders, because in that case, it is a very, again, like I said, that's the one case on demurrers to solicitation charges. In that case, they didn't really allege anything. In this case, we allege who was solicited, where they were solicited, how they were solicited, what they were solicited to do. There's a laundry list, why they did the solicitation. It's not a mystery of what these defendants have to be prepared to meet at trial. That's the ultimate question. Do they know what we're talking about? Does the indictment tell them what crime we're talking about? And does it protect them against double jeopardy? And when you read it as a whole, it's very clear. It tells these defendants what conduct is being charged. It prevents double jeopardy, and that's sufficient to withstand a special demurrer.
Knowing in the indictment what the oath was, I don't know how Mr. Wooten can seriously say we know what we asked them to do was a crime if we don't even know what the oath was or whether they even took an oath. The problem here is there's a number of ways that I think Mr. Wooten mischaracterizes our motion. If I asked someone to, go cross the street or something, and he would say, well, you asked them to cross the street, and we're claiming that that's a violation of the law. You'd have to say, what law did you violate? What law did you ask him to violate? And define the elements of that crime. They're just saying, they're not even saying that we asked anybody to violate their oath. It doesn't even say that we said, I want you to go out and violate your oath. However you feel like doing it, just go violate your oath, Chris, okay? Just go violate your oath. It's a compound crime that requires that we have knowledge and intent that you will violate the oath. We're soliciting them to do something to violate his oath, and they won't tell us what the oath is. Sanders talks about compound crimes, that you have to allege the elements of the various aspects of a compound crime. It's not just the controlled substance case in Sanders. The prosecution conceded that the felony murder count was also defective because all it said was you committed felony murder in the course of an armed robbery. You didn't allege the armed robbery sufficiently. And I was worried that the prosecution conceded and that was it. But no, Justice Bethel said, and appropriately so. They were right in conceding because even that count of the indictment was defective. Both the felony murder for not alleging the compound nature of the crime, you got to prove both of it. And the fact that the oath isn't provided at all. And of course, the other part of Sanders shows the level of detail. And listen, if you want a list of special demurrers, I can send you a supplemental list in 5 minutes because we're dealing with the same issue in the Cop City case. And there's just dozens of cases in the Georgia Court of Appeals which have held that the defendant is entitled to know what you're going to prove at trial. Otherwise, we can't prepare a defense. I still don't know. I know I said that he shouldn't stand up and tell us what the Constitution was. Maybe informally after court today he'll tell me. And at least we'll know then if you don't grant the special demurrer. But the law requires, respectfully, that you grant a special demurrer and say what was the oath and why, what clause of the Constitution, assuming it's the Constitution, was your oath, what clause in the Constitution do you claim it violated? Was it Article 2, Section 1? that Mr. Gillen talked about this morning? Was it the Equal Protection Clause, due process, whatever? It's not to violate a Georgia statute, because I can't find that anywhere. So if he was asking the four of them, or however many people in the count of the indictment, asking them to shoot someone, it wouldn't even be a violation of their oath of office, because legislators, apparently their oath doesn't include don't violate Georgia law, like police officers. We're entitled to a special demur. The special demur be granted. We're entitled to an indictment that is perfect.
All right, thank you, Mr. Samuel. Why don't we take a hard 5 minutes and be back and see how much further ground we can cover. Starting to think we may need to reconvene, and we'll see what we can do then. All right, be back in 5.
Stay seated, court, come to order.
Okay. All right, back on the record. Item 4, false statements and false writings.
Your Honor, I have more PowerPoints. Access.
Oops. Okay, here we go. All right.
Your Honor, the attacking certain accounts of the complaint because they do not, as Georgia law requires, plead out every element of the Supreme Court is clear that in order to withstand a demur, the state needs to plead every single element of the claim and needs to plead facts sufficient to show that. With regard to 16, 10, 20 counts, which is counts 4, 3, 4, 13, 19, 25, and 26, the state does not do that. Where we start is a Haley versus State case that I talked about earlier. 16, 10, 20 makes it fine to knowingly make a false statement to government within the jurisdiction of the state or local department or agency. What the Haley court found, and Justice Namias wrote, is that if you were to look at that statute and just say that it had those two simple requirements, that it just said that the defendant must knowingly and willfully make a statement, and that the false statement must in fact be within the matter of a jurisdiction of a state, department, or local agency, that would be unconstitutional. It would be unconstitutional because the second element, the false statement must be made in a manner within the jurisdiction, also has to be made knowingly and willfully. And Justice Namias went through great lengths to say that were it otherwise, the statute would be unconstitutional. And the court was very concerned about it, so it narrowly read and I think did a lot to try to help the statute. But they said, if a person making a false statement need have no knowledge of intent of any kind, that his deceptive statement will come to the attention of a government agency within the authority to act upon it, then the basic due process notion of fair notice would be in doubt. And 161020 would criminalize a wide array of statements that would have always been deemed, at least legally, doesn't have to be morally, at least legally innocent, and the statute would be a trap for the unwary. And so in trying to rectify the First Amendment and due process concerns.
So, Mr. Knowles, I do remember the Haley case. Yes. and the issues that were raised there. And so jump into the heart of it. Yep. If I remember, actually, the language in Haley spells out what was charged. And it says that it was sufficient, right? So sure, it read in an interpretative way an extra element, but did it require or create a pleading requirement? And how so?
The answer to that question is yes, it did create a pleading requirement. What Haley was doing, it was a statutory interpretation. They were going at the statute head on and saying, listen, the statute is unconstitutional. Justice Namias was going to read it in a constitutional way. And so he said to avoid the constitutional problems that he was concerned about, and they're long, and then footnote 1, which is in my presentation, but you can also read it, talks about some of the absurdities. He said to avoid these absurd and patently unconstitutional result, the court imposed a mens rea requirement on 161020's jurisdictional. And what he said is, he said, we conclude that a false statement, when properly construed to require that the defendant make the false statement with knowledge and intent that it may come within the jurisdiction of a state or local agency, is constitutional. And he said, accordingly, we hold that 161020 requires proof that 1, defendant knowingly and willfully made a false statement, and 2, that he knowingly and willfully did so within the jurisdiction of the state or local department. Those are the 2 elements of the crime.
So that was a element created through that, or recognized through that opinion. But generally, when we're talking about whether a indictment is pleaded sufficiently, we're talking about the elements imposed by the statute. And so did Haley go so far as to say that there was a statutory element that was created?
I think that what Haley did, and if you read it, in my view, what he did is he said, okay, listen, within the 4 corners of the statute, I see the word knowingly and willfully in there. And the way that the statute is written, it's kind of unclear whether that is transitive across the words that are there to get to jurisdiction. But I'm going to read it because it's so unclear. I'm going to say, yes, it does apply there. Okay? So Justice Namias said, listen, okay, it says that. It says knowingly and willfully made a statement and knowingly and willfully within the jurisdiction. So both of those are elements. And what we know from the cases that Mr. Samuel said, from Kimbrough, from Jackson, from all these cases, is that you have to plead every element of the crime. The court has explicitly told us what those elements are, and they are not in count 26.
And it's split them up, but the language of the statute remained the same.
Right, the language of the statute, but that's like my saying, and I'm probably going to get this wrong, but I have a brown coat and tie. Brown goes to coat and brown goes to tie. The way that Justice Namias read the statute, the Supreme Court, I keep saying, the Supreme Court read the statute.
You have a brown tie and a brown shirt. But is that a pleading requirement? I just don't see Haley getting to that point. It's an interpretive requirement.
Haley doesn't say that that's a pleading requirement. What Haley says is that those are the elements of the crime. And then we see the other case law that says you have to plead every element of the crime. So, of course, and how do I know that's right? Because I know that's right because Justice Namias said, if you don't have to knowingly and willfully have the jurisdiction, unconstitutional. So you have to have those 2 elements. And when we look at the manner in which every single one of these counts is, I have an example of here, which is count 26 with regard to Mr. Cheely, but it's the exact same language in 4-13-1925. They break it up into 3 things. Number 1, it says, this is what it says verbatim, excuse me. And so the first part says, and the grand jury, in the name and behalf of the citizens of Georgia, do accuse Robert Cheely with the offense of false statements in writing for said accused in the county of Fulton in the state of Georgia on or about the 30th day of December 2020, knowingly and willfully and unlawfully made at least one of the following statements and representations to members of the Georgia Senate present at the Senate Judiciary Subcommittee, colon. So what does this say? This says that he made a false statement to the Georgia Senate Subcommittee, okay? Maybe that meets element number 1 of Haley, knowingly made a false statement. As a little side, we know that the second part, made it to the Georgia Senate Subcommittee, is irrelevant because the Georgia Senate Subcommittee is not an agency or department of the state. The state concedes that in their briefing. So the first part, knowingly and willfully made a false statement. What does the second part of the count say? Well, here it goes on to say, well, this is what they did wrong. These are the false statements, that they saw a water main break, and that they voted ballots over and over again. Again, we pointed out in our brief, D.A. Willis has made these same comments, but has not, but decides to prosecute Shealy for them. But in any event, those are the second part of what count 26 says. So then we get into the last part of what count 26 says, and this is the critical part with regard to Haley. It says, said statements being within the jurisdiction and office of the Georgia Secretary of State and the Georgia Bureau of Investigation, departments and agencies of state government, county, and law enforcement agencies. What those are, I do not know, and that would in and of itself require special demur, but contrary to the laws of said state for the good order of peace. Haley explicitly says two elements. Number one, knowingly made a false statement. Number two, knowingly did so within the jurisdiction. What does this explicitly not say? It doesn't say that they knowingly and willfully did it within the jurisdiction. Now, that in and of itself warrants the dismissal of all of those counts because every element of the claim is not made. Why they did it, they had 2.5 years. They either A, didn't have the belief or the proof for it, which I don't think that they could have possibly had. And so in good faith, they didn't put it in there. But it is not in the indictment. And because it's not in the indictment, those counts fail. It's a mechanical issue, and it's an important issue because they are essential elements of the claim to make the claim constitutional. And that's exactly what the Supreme Court has told us. The only place we see knowingly and willfully at all in the statute is with regard to the first portion where it says you knowingly and willfully made it to the General Assembly, but you cannot give a fair reading of count 26 or any of these other counts to say that that phrase somehow carried forward into the rest of the paragraph. And you have a number of breaks. I put some grammar rules here saying that a qualifying phrase should ordinarily be given as modifying only the noun that immediately precedes to it. But what do I know about this? It's an adverb, right? And when I look at the said statements being within the jurisdiction, what verb would that modify? None. So it is not in there, and it's just not there, so the count fails. A couple of other statements about these claims, counts 4, 25, and 26. These are, again, statements made with regard to the Senate subcommittee. These statements are to a General Assembly. They're protected. Okay? The General Assembly, and we put this in our brief, has made the conscious decision that they are going to encourage, going back to my First Amendment argument, are going to encourage as much free speech as they possibly can to allow people to come and speak in front of them. They do not have an oath requirement. They do not have subpoena power. The statute that allows, I think it's the Ethics Committee of the House or Senate to go, they'd have to come to this court to get a subpoena, but the House and Senate have no other oath abilities, no other subpoena abilities. As we point out in our brief, in the 2021-2022 session of the General Assembly, they sought to introduce that requirement, saying that everybody that comes and speaks before any committee could be under oath. They made the conscious decision not to do that, and they do it to encourage people to go testify. I've testified down there. I've seen some nutty stuff said, and I think that they just want people to come and talk. Well, if that's their goal, and that is within the General Assembly, they are encouraging through their committee meetings and asking people to come and speak. When the executives of this state and the DAs of this state are coming in and prosecuting people for going in front of the General Assembly to give them statements that the General Assembly or the subcommittees are asking for, that impedes upon the power of the General Assembly, and it is without the jurisdiction of these various entities that are put in 16, 10, 20. Moreover, if you look at counts 13 and 19, and this relates to the statements regarding the electors, and Mr. Samuels points this out in one of his briefs, these cases relate to statements regarding the electors. They don't plead mens rea anywhere. when Mr. Samuels made that point, the state in its brief says, aha, we don't say who the statements were made to at all. We don't say who received the document, who relied upon it. And if they don't say that, then for all the reasons we just talked about with regard to the oath, that fails to provide adequate information with regard to the claim. And because they don't say to whom the documents were given, to whom these allegedly false statements in counts 13 and 19, that's subject to the special and general demurrer. We've talked about it being barred by the Electoral Count Act, barred by First Amendment, and barred because, again, applying the rule of lenity and due process, nobody ever in this state has been prosecuted for going in front of the General Assembly and telling them something in front of a committee or a subcommittee, not ever, not once in this state. And I don't think that the state can show you anything to the contrary. And because of that, I think that we see, and the reason you don't see that, again, the First Amendment, again, because it's within the province of the General Assembly, it simply is inapplicable, and the state's attempt to assert these 1610-20 claims fails for all these reasons, primarily because they don't plead the knowledge requirement, and then secondly for the other reasons that I've raised. Thank you, Your Honor.
Judge, I'll start with Haley. The indictment is not required to allege that a defendant knew that false statements would come to the attention of a covered entity. That's an evidentiary concern, not a pleading requirement. How do we know that? Because in Haley, I flipped the slide, Haley told us exactly what the indictment in that case alleged. It did not allege that. And if the indictment in Haley had to allege that in order to allege a crime, then the court in Haley would have dismissed the case because the indictment itself never alleged a crime in the first place, and a general demurrer issue can be raised at any time. So it clearly does not impose an additional pleading requirement. You have to separately plead knowing and willful as it relates to knowledge that will come to the attention of someone. That is purely an evidentiary requirement. The trial does not impose any additional pleading requirements. It's irrelevant that the legislature is not a department or agency of state government. Haley tells us that as well. Simply, the false statement must concern a matter within the jurisdiction of a municipal, county, or state department or agency. To whom that statement is made is not relevant. In Haley, it wasn't made directly to any person. It was put on YouTube, and it was put out for public consumption. And coincidentally, in this case, the legislative hearings were broadcast on YouTube as well. The contention that the false statements cannot be prosecuted because the same statements were made in immunized legal pleadings, that's unsupported. There's no authority that legal pleadings are immune from prosecution. This was raised in the briefs. To the contrary, there are specific statutes that criminalize false statements in pleadings, and we cited in our brief a couple of instances, such as an attorney being disciplined for making frivolous pleadings and filings. OCGA 51-911 creates a civil cause of action for defamation of title involving false pleadings, and then 1610-20.1 obviously makes it a felony offense to file false documents. So I'm not sure where this idea of immunized legal pleadings comes from, but it's not supported. Legislative privilege does not apply to statements made by third parties to legislators. Defendants, again, provide no authority for that contention. It's raised in the briefs. Look at the Constitution, the constitutional provision, Article 3, Section 4, Paragraph 9, that creates legislative privilege. It's very clear that it applies to members of either house, not to the general public who shows up and serves as a witness. The fact that they're not under oath, again, is not relevant. That would create a different crime. We're talking about false statements, and we've alleged the essential elements of false statements. Again, under the defendant's theory, in Haley, if that defendant had come to the legislature as a witness and said that he was the catch-me killer and killed 16 people, knowing that that was going to be broadcast live to the world, for whatever reason, he would be immune because he said it at the legislature. That doesn't make any sense. There's no requirement that the counts concerning false documents allege that they were used anywhere in particular. That's not an element of the offense. In any case, we talked about how, for special demurrer purposes, you can look at other counts of the indictment, and other counts of the indictment allege where those specifically named documents were used, how they were used. And this is the citation I was looking for in the last argument. Although each count of an indictment must be complete within itself, contain every allegation essential to constitute the crime, that applies to the offense, not the form, and the indictment is read as a whole. Special demurrer, of course, is a challenge to the form of the indictment, so that rule of count having to be complete does not apply in the context of a special demurrer, only a general demurrer. We got an argument in the pleadings that the Secretary of State and the GBI don't have jurisdiction over these false statements. That's looking at facts outside the indictment that constitutes a speaking demurrer. There's no requirement, this is raised in the briefs, that the counts alleged defendants knew that their false statements would cause harm, not an element of the offense. No authority that false statements cannot apply to statements made to the federal government, raised in the briefs. Again, the recipient of the false statement is not an element of the offense. So it doesn't matter. As long as we allege that it's in a matter within the jurisdiction of one of these agencies, and then we prove at trial that there was knowledge that it would come to their attention. In any case, the indictment alleges that those false documents were also transmitted to state officials. And again, we got the rule of lenity argument. We saw this come up a lot in the pleadings. I think this is the first time that it's come up.
I think you handled that. I haven't seen it come up yet today in argument. I think you've addressed it in the briefs.
I think it briefly was mentioned in argument.
We hear it? Okay.
And so just to highlight here, I understand that there's kind of there's a lot of federal case law that was cited in the briefs on this issue, but the Georgia version of rule of lenity, where we see it applied over and over again, is that it's a rule of sentencing. So if you get convicted of two offenses, one provides a lesser sentence, but they're the same act or same elements, you're entitled to the lesser sentence. The Court of Appeals this year noted that the defendant in Huber, 368 Georgia Act 401, has provided no authority, and we have found none, for the proposition that the rule of lenity can subject to demur an otherwise sufficient indictment. So our position is that while there may be in the federal cases that are cited a different application of the rule of lenity under Georgia cases, it's not a reason to dismiss the case. Motion should be denied as to these counts. It's irrelevant where or to whom the false statements were made. There's no support for this idea of immune legal pleadings. Legislative privilege only applies to legislators. In a few situations, they're staffers. And other arguments seek to add elements that are not set forth by statute, or they're simply avoid speaking.
All right. Thank you, Mr. Wooten.
Very briefly, Judge, if you're going to have to prove something at trial, it's an element of the offense. If you don't have to prove it at trial, it's not an element of the offense. Obviously, Haley said it is an element of the offense that you knowingly and willfully do that. They don't plead that. They have no response to that. They admit they don't plead it. The claim has to go. With regard to legislative privilege, we're not arguing legislative privilege. What we are arguing is that when somebody comes and speaks in front of the legislature, we have a separation of powers problem, because if they're speaking in front of the legislator, invited to do that, and somebody comes in and hits them for what they say in front of the legislature, that is an issue. And with regard to the rule of lenity, that's exactly what Haley was doing. Is the rule of lenity is a rule of statutory construction, and when you're looking at these statutes, you have to interpret them in a manner that would make them constitutional. If it's ambiguous, you read them against the state. And here it says you've got to have these two elements. One thing that I would want to point out to Your Honor is we've seen this obviously in the Haley case and in others. In the federal context, there was a case, Rahif, that talks about criminalizing the possession of firearms by a legal alien. And the Supreme Court, much as in Haley, came back and said, listen, you have to have both elements have to be knowing. I have to know that I possess a firearm, and I have to know that I'm illegally in this country. And those both became elements of the crimes. The United States U.S. Attorney's Office have changed their pleading requirements for that, and have done exactly what the state should have done here, which is modify the way that they plead these cases. And what they should have pled here is that said statements are knowingly and willfully within the jurisdiction. That's not there. The claim fails.
Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.